Recent tragedies, both obscure and highlighted in the media, underscore the role of science in crime. In the background, even now, science is being used to investigate what happened to Michael Brown in Ferguson, Eric Garner on Staten Island. Science helped us to determine that Victor White in Louisiana was shot in the chest, not in the back, as police reported. And science cleared 2 half-brothers in North Carolina after 31 years in prison. And there are many other cases we're going to talk about tonight, recent in our memories and some rather distant. Complicated investigations are underway, and what we're going to see in our discussions this evening with our very, very well-known experts is that some of these investigative and scientific techniques are helpful in the assessment of crime and in the courtroom in weighing guilt and innocence, but some aspects of science are not so definitive as we have often thought. So let's get started. Our first participant has pioneered the scientific study of police interrogations and false confessions. He is a professor of psychology at John Jay College of Criminal Justice. Welcome, Saul Kassin. Next up is the co-founder and co-director of the Innocence Project. He's provided direct representation and critical assistance in the majority of the more than 300 post-conviction DNA exoneration cases. We are so pleased to be joined tonight by Peter Neufeld. And also with us tonight is New York Times columnist, Pulitzer Prize winner, and finalist for the National Book Award, author of a number of books, most recently the innovative interactive book, False Confessions, Innocence, Guilt, and Science. Please welcome Jim Dwyer. And our next participant explores the intersection of criminal law, political, and legal theory. He is a professor at Cardozo School of Law and writes about policing and the role race should play in jurisprudence. Please welcome Ekow Yankah. Science, of course, passes through each stage of the criminal justice system. We start with the investigation, the collection of evidence, and we're going to talk about that in detail in a bit. But even before the evidence is collected, the witnesses, if there are any, have seen what went down. How reliable, Peter, are eyewitnesses?
Well, some eyewitnesses in certain situations can be reliable. But what we have found again and again and again is far too frequently eyewitnesses are simply mistaken. Not lying, but they're mistaken. The problem is if you've ever sat in a courtroom when an eyewitness testifies and points the finger over the defense table and says, "I will never forget that face as long as I live, as God is my witness," that's the end of the case. It doesn't matter what the defense puts on after that. They've heard that, the jury needs closure, and that's the end of the case, whether or not that witness's testimony is in fact reliable.
Well, Saul, then let me ask you from a scientist's point of view. What does science tell us about our brains? Because Peter says they may not be lying. They may really believe they're telling the truth. They may believe they saw what they think they saw. But what does science tell us about our brain and the ability to remember during a stressful situation like a crime?
Well, first of all, from a cognitive perspective, there are different reasons why a witness may not be able to make a correct identification. For example, one possibility is that the witness, who may have been physically present at the crime, may not have paid attention or noticed. There is a phenomenal demonstration I would urge everybody in the audience to Google. It is called Gorillas in Our Midst. If you've seen it, you're laughing. If you haven't seen it, go to it. I've spoiled it for you as a subject, but take a friend through it. It is a demonstration that shows 6 people, 3 wearing white shirts, 3 wearing black shirts, throwing around a basketball. And you instruct the subject to pay attention and count how often people in the black shirts touch the ball. So they're deadly focused on this 1-minute film of people throwing the ball and counting the number of times it hits somebody wearing a black shirt. While they're doing this, in the middle of the film, a guy dressed in a gorilla suit walks in. And he walks right across the center of the stage, stops in the center, pounds his chest, makes a funny face or two, and leaves. more than 50% afterward don't notice there was a gorilla. They're looking right at him, but they didn't notice because they were so focused on something else. So sometimes the witness just doesn't notice because they're not paying attention. Attention is something we can divide. We can't allocate our attention multiply to more than one thing.
All right, so we've talked about the moment the event may be happening, and I actually jumped ahead and asked you about the testimony and the jury eating it up, you know, that Hollywood moment. I saw him, that's the guy. But Jim, take us back for a moment to the questioning that the police do of the witnesses. What goes on there that might complicate the equation?
Well, if the detectives or the investigators have a suspect in mind, they will show the witness a bunch of pictures. Sometimes they'll be in an array, sometimes they'll be one at a time, and they'll say, do you see anyone who was involved in the crime? Or they'll ask some form of that question. And there are ways of asking that question that can be suggestive. How about that one? How about that one? How about that one? And you can send signals to people in any variety of subtle ways or unsubtle. And then afterwards, the witness can be encouraged to believe their identification.
Now, let me just ask you a follow-up there. Are they doing this on purpose?
No, I mean, cops
Is this a
want to get...
subconscious thing
Right.
the cops are doing? Are they? What's going on in that moment?
The police officer is trying to do what everybody else in the chain of the story is trying to do. They're trying to complete a narrative. If you think about the whole criminal justice system as a way of telling stories, I think that you can understand how things go awry. When we hear stories in our personal lives, we get them messed up. You know, two people see the same thing, they tell a different story about it. And how the police elicit information, you know, they want to do it in the most straightforward way possible, but they want to get that story told.
Well,
We had a case just recently where not only are the police doing it inadvertently, but from the witness's perspective, they're shown this array. The police really want to solve the crime. And really what's going on when they show this six-pack, that normal six-pack you see on TV and the movies, is that the witness is thinking to herself, wow, who among these six people looks most like the guy that did this to me? So they tend to make that relative judgment. And they want to help, and the officer wants to help. And so they look at one, then they look at three, they look at one, they look at four, and back again, and wow, one looks most like the person, I'll pick one. I'll also pick one because, you know, if I don't pick somebody now, they may forget about this case, I won't have closure. All those emotional factors are in play.
and then, of course, there are the complicated cases where they might recognize someone in the six-pack, or they may have seen them from some other circumstance in their life. But Ekow, let's assume they don't recognize anyone. There's no deliberate manipulation by the police. It's inadvertent. What then should happen in the system?
So this is one of the problems, and Saul was speaking about how our memories work. And the problem is it's very hard to undo this once somebody discovers or decides who they saw. So what you actually learn when you spend time talking to people who study the way in which we cognitively process things, is that we're much more directing a movie, directing a narrative, than we are a recorder, right? We think of our memory as though it was simply recording, and this is just not at all how our memory works. We fill in stories. Here's a silly example. How many of you remember something that you couldn't possibly remember, right? That thing that happened when you were 2, right? But your family's told the story so many times that it's become embedded, and you actually remember. I mean, if somebody asked you, you could describe it, and until you take a moment to think, oh, right, I don't remember it, right? You can let it slip in your own mind. You can
You've
forget.
manufactured that memory.
You can forget that you don't actually remember it, so to speak. So the problem is, and this touches on all the answers, the problem is that once the person decides it was this guy, and they've decided this for the reasons that we think. They saw the picture, they decided it was the closest to the person, they wanted to help. Now that person actually becomes the person in your mind's eye. So it's not surprising that jurors believe you because you're speaking with a great deal of confidence. Right. You truly believe it's that person.
Conviction.
And unfortunately, what the studies show, it's really stunning. the confidence with which people identify somebody has very little correlation at all with the accuracy, right? Let me wrap it by just saying what that means. These two people are equally likely to be accurate. It was dark, I can't tell, it was hard, it all happened so fast. And for the rest of my life, I will never forget that face. They're equally likely to be accurate, right? But of course, one has a devastating impact on the jury, and it's very hard to undo.
Peter, I want to come back to something you said. You were talking about the six-pack, which are the 6 photos we see in a photo array. And I probably should have started by asking, what are the different ways in which, and you did touch on it, but let's very clearly lay out the different ways in which police will ask a witness to make an identification. We've seen it on television, but let's just go through it for the audience.
So in the rest of the country, not New York, they will simply do a photo spread like the one I was describing, the 6-pack. In New York, because of a certain statutory construction here a number of years ago, where they determined that a photo identification is not admissible as part of the prosecution's direct case, if there's a photo identification, they will then try and corroborate it with a corporeal lineup. The 6 people standing up against the wall that has their heights behind them.
Live bodies.
Right, live bodies. And of course, the other way that identifications are made is with a show-up, which under our Constitution is permissible if it happens shortly after the incident, or if the witness or victim is dying or in some other kind of emergency condition. Other than that, they frown upon the one-on-one show-up. So most of the time you're talking about the corporeal lineups, the live lineups, or the show-ups. The problem with the lineup, of course, is just as Ekow was saying, is if you've already picked the person out of the photo array, and now 4 days later there's a lineup, well, the only person from the photo array who's in the lineup is the one person who you just saw, so he is the familiar face. And it's very difficult cognitively to distinguish between having really seen somebody and the familiar face.
Right. And Ekow, what about cross-racial identification?
So the studies,
identifying someone of a different racial, or I guess even ethnic group?
yeah, I'm going to just be a little colloquial. People can't do it. Just flatly can't do it, right? So people are terrible at cross-racial identifications, right? So you can all insert your own joke about how everybody of some race that you're not looks exactly the same, right? You know, it's a joke, and it can be a terrible joke, it can be a mean-spirited joke. It just happens to be true, right? And it's not because they all look alike, it's because you're terrible at it. So, you know, people do study after study, and cross-racial identifications are very, very difficult for people to do.
Jim, you've encountered this in your writing and your reporting, that witnesses, as certain as they may be, I mean, really, the witness who says, God, I'm just really not sure, it was dark, and everything Ekow said, that person, in some ways, if you stop and think about it and use your common sense, might be more reliable than the person who's altogether certain.
That's right. Yeah, you know, it happens to be the anniversary coming up tomorrow of 9/11, and a project I worked on some years ago, we reconstructed what happened inside the building. And there was a famous episode of a man in a wheelchair who was on the 23rd or 25th floor, right? And he was his friend stayed with him. It was a big motorized wheelchair, and so we interviewed a lot of people who saw them waiting for help in the stairwell, and I tell you that we got 20. Well, we didn't get 20 different answers, but if you ask people what floor were they on, I'm sure it's the 27th floor because there was a Coke machine right there. It was the 25th floor, that's where Blue Cross Blue Shield was. It was positively the 26th floor. And on and on and on. And the way we were finally able to figure it out was through a tape recording where somebody said, there's a man here on the 25th floor with a wheelchair. So all of those people were under, of course, tremendous amount of stress, but it was very memorable to them that these two men were in the hallway there. So yeah, you do see it all the time.
Point
yeah.
very clearly. Now, Saul, we've known then for a while that eyewitnesses are unreliable. That's not really a new thing. But when did we begin to make the point with experts to judges and to courts and try to establish this to juries?
That actually is a very recent development. In the 1970s, some important papers were published, and as a result of those papers, experts, psychologists began to testify on the issue. And the issue is twofold. The first problem with eyewitnesses is they make mistakes, either because they failed to attend or because they attended but failed to process and record the information properly, or because they're exposed to a suggestive lineup. But the second problem is that the eyewitnesses who say, well, you know, the lighting wasn't so good and I'm not so sure, those are not the witnesses you see in court. The witnesses you see in court are what we described earlier.
That's who the
I
prosecution
will never
would call.
forget that face. And I defy any judge or jury to disbelieve that very confident witness. It is, the first problem is witnesses make mistakes. The second problem is the confidence is not the cue to use. And the third problem is that judges and juries use confidence in order to determine accuracy.
But we have been studying it since the turn of the century, have we not?
Actually, psychologists have been studying memory since 1870 in a laboratory. It was in 1908, a Harvard psychologist by the name of Hugo Munsterberg wrote a book called On the Witness Stand, in which he took it out of the laboratory and made the point that eyewitnesses in real-life situations can make mistakes. Munsterberg used to demonstrate his point by staging demonstrations in lecture halls and classrooms like this. And, excuse me? The field has come a long way since those silly demonstrations.
All right, so you've had your first on-stage crime of the evening.
Round up those witnesses,
I was blocking your
please.
view, so you're at a disadvantage over here. But if you look at the back of your program, you'll see that there's a chart, and in the course of the next few minutes or the next hour or so, you can make some notes on what you think you just saw. And we'll see how well your eyewitness IQ, how high your eyewitness IQ is. Now we're going to actually turn, that was a lighter moment, we're going to turn now to a more serious, as most crimes are, a much more serious moment. We're going to talk about eyewitnesses who have to make an identification having been the victims of crime, which can be the most difficult. And you would think if you're the victim of the crime, you can actually observe what's happening better than anyone else, because there you are in the middle of the situation. You're looking directly at the perpetrator, presumably in most cases, but that's not the case, it seems. And we're going to talk specifically about a case that some of you may be familiar with, the case of a woman named Jennifer Thompson. I want to let you know that this involves a sexual assault, and it can be rather disturbing, the subject matter. So this is from False Conviction, Guilt, Innocence, and Science. This is a small piece of Jennifer Thompson.
It was early in the morning. I felt something in my room, something brushed my arm, and when I looked over to the side of the bed, I noticed it was a person's head, and that's when I said, "Who is that? Who's there?" And he immediately sprang up on the bed and straddled my body and put a knife to my throat and told me to shut up or he was going to kill me. Over the next 20 minutes during the assault, as he raped me, I made two decisions. One is if there was a way I could live, I would figure it out. And if I lived, I wanted to memorize everything about this person. So I began to pay really close attention to details about his face and his eyes and his voice and his hair and how much he weighed, the clothing he was wearing.
What Saul, about Jennifer Thompson's testimony is so very interesting?
What is interesting about Jennifer Thompson, several things. But first, unlike the situation where a witness may be physically present but just not paying attention, she paid attention. She paid close attention. One of the problems psychologists have recognized about eyewitness testimony is even when a witness is focused and motivated and their attention is locked and loaded, they still make mistakes. That's Jennifer Thompson. Two, she didn't just make an identification from a lineup, she made it with a high degree of confidence. She was absolutely certain. She talked herself into remembering that face and then picked the person she thinks she remembered. Third, when she was confronted years later with the fact that the guy she ID'd was DNA exonerated, and the DNA actually did match her rapist who was in prison for other sexual assaults. And she was confronted with that rapist. She said, no, that's not the guy. The person she misidentified years earlier became her memory of that rapist, such that she could not even see the rapist for who he was when she finally did see him.
How does that happen as a matter of science in the brain?
As Ekow said earlier, the brain is not, memory does not work like a videotape recorder. Memory is constructed, and it is reconstructed. So if a witness sees something and then receives additional extraneous information, if, for example, I watch a car accident and then the police ask me suggestive questions about that accident, or I hear other witnesses recounting things they saw about that accident, those extraneous pieces of information may become part of my memory.
So Jim, tell us a little bit more about Jennifer's story.
So Jennifer was taken down to the Detective Bureau, and she was shown photographs, including a six-pack, and she got to one of the six-packs, and there were two that she was going back and forth between. And finally, she had this sick feeling when she saw one of the pictures. And she said, I think it's number 4. And the detective said, you think? No, I'm sure that's number 4. And the detective said, good, he's a scumbag, he's the one we thought did it. Her certainty thus buttressed. They went out a few days later and picked up Ronald Cotton, who was number 4 in this array. So when they brought him down for the lineup, Jennifer said, that's the guy. And they said, yeah, he's done something like this before. He likes to attack white women. In fact, he had had a statutory rape charge involving a girl he was dating some years earlier, but it was quite different situation. But Jennifer then became absolutely positive of her identification of Ronald Cotton. Years later, they actually brought the guy into court because Ronald's first conviction was overturned on procedural grounds. And in the meantime, the guy who had really raped her was arrested for other crimes and sent to prison and told other prisoners that he had done so, that he had raped Jennifer. And they said, okay, well, let's bring him into court. And Jennifer looked at him in the courtroom and said, no, that's not him, it's Ronald Cotton. So Cotton was convicted a second time.
But what happens ultimately in the story?
Ultimately, the DNA proves that it was the guy who had been brought into court 9 or 10 years later, and Ronald Cotton was released. There is a bit of a happy ending to the thing, which is that Ronald and Jennifer actually became friends and wrote a terrific memoir together called Picking Cotton, and they talk about their experience. Sorry, I mean, that was the title.
You didn't choose the title.
I didn't choose the title, no.
And it was a cross-race identification.
It was a cross-racial identification.
It is important to point that out.
Yeah.
And I could go to, there are 2 places I want to go here. Let me go first to Ekow. Let's talk a little more about that cross-racial misidentification, clearly leading to the conviction of this innocent man. Let's talk a little bit more about her confidence in making that identification.
Yeah, so there are 2 things here that are, one is strange in our personal life, but the other is just devastating. So the one that's strange in our personal life is starting to understand that people's confidence and their accuracy are not very closely correlated. Now, you know, the really smart people work on this, right? And the worst studies say it has no correlation, just none at all. Other studies aren't so confident, forgive me, that there's no correlation, but nobody thinks that confidence has a high correlation. And that starts to be weird in your personal life, by the way, right? It really let this sink in and start realizing that when your friends are telling you stories, they have no idea what they're talking about, right? And it starts to have an effect on you. And they're not bad people. They don't even have a motive to lie to you. They're just real people who are reconstructing their memories as they speak. Here's the one that's more devastating. So the most fundamental thing on which we run our trials is the idea that by this what some people think of as slightly strange confrontational method, having witnesses and examinations and cross-examinations, we will get to the truth. And if you really realize that witnesses are a not intentional, but very shaky source of evidence, you've got to start thinking, what are we even doing? Now, I want to be fair to police officers. It's not like police officers get a witness and then close up shop, right? Smart police officers.
A lot of other stuff we're going to get to.
Yeah, most police officers work very hard to correlate, or to, I should say, to coordinate witnesses with great evidence. Most police officers are perfectly aware of the phenomenon that you saw a bicycle when there was no bicycle involved in the accident, et cetera, et cetera. You know, most police officers try very hard to be competent. But it is true that at the heart of the American criminal law system is the idea that witnesses are the way to go. And once you start understanding that witnesses are a data point, but a really shaky data point, you would think we would deeply rethink the way in which we address criminal trials. But we still have sort of a folk belief that if people really believe what they're saying, that the jury will do a good job telling who's lying and not.
I just disagree with one small aspect of that, which is that quite often with police officers, cognitive bias plays has a lot to do with it. So when an officer is told, even though he wants to do the best job possible, that this suspect is a really bad dude, okay? Even unwittingly, that's going to affect the way he processes the data, how he processes the evidence, how he processes the witness, okay? If he's going to do an interrogation, it's going to affect that.
And Peter, can you explain very plainly what you mean? Because this cognitive bias is a part of every subject area we're going to approach tonight. So explain very plainly what you mean by that.
So Saul will correct me, but putting that aside for the second.
Only if you're wrong.
Okay, basically what we're saying is that this is not the kind of bias like, you know, you don't like a certain class of people or ethnicity. This is a kind of bias that the brain simply processes and you're not even aware of it, okay? And we all have those cognitive biases. If we learn a certain amount of extraneous information that is not necessary to decide a certain question, but it's powerful information, it influences our decision making. There are thousands of articles that have been written on that. It's not controversial, it's not in dispute, we all do it. And so what we have been trying to do at the Innocence Project, for instance, is come up with different ways of conducting investigations and analyzing evidence to minimize cognitive biases. And that's what we're trying to do, whether it's eyewitness testimony, interrogations, later on we'll talk about forensic science, but in all these things, if the people who are making decisions, which could be the police, it could be the district attorney, it could be a criminalist working in a laboratory, if they have this extraneous information, it can't help but to influence their decision making.
Can you give an example of how that would, because we do need to move on to the next area, false confessions, but can you give an example of how cognitive bias could be eliminated, reduced, or at least we'd be more aware of it in the area of eyewitness interviews or identification?
So the simplest thing for eyewitness interviews, okay, is to make sure that the police officer who actually conducts the photo spread or the lineup, that officer doesn't know who the suspect is. So that officer is doing it blindly. The same way you would expect an analysis to be done in a research laboratory looking at some new, cure for some rare disease. You don't want those people to know who has the disease and who doesn't. They look at the data blindly. Similarly, you want an officer to conduct that eyewitness identification procedure blindly, not knowing who's the suspect. Because if they do know who the suspect is, then as Jim Dwyer pointed out, they'll say, well, what about number 3, Mrs. Smith? And they won't even be aware of the fact that they're asking that.
If it's that simple, Jim, why don't they do it that way?
Well, if I could jump in with a question to Saul, which might help answer that.
Go ahead, and then we're moving on.
Yeah. So, Saul, we know now eyewitnesses can be really untrustworthy or unreliable. Do we know what are the indications of a reliable eyewitness? What is consistent with good eyewitness practice? Because I do want to believe somebody's telling me.
Is there such a thing?
Well, there are risk factors that increase unreliability, right? So
Yeah.
if there is a weapon drawn, that brings real accuracy rates down because
Right.
people's attention goes straight to the weapon and they lose the face. Stress can compromise, intense levels of stress. So at best, what we can do is we can say, in the absence of some of those problems, distance, darkness, stress level, the presence of distracting objects, the witness could be a reasonable witness.
Is it true, though, that if
Race.
a person is in the lineup room and their degree of confidence in the lineup room is very high, not when they get to court, but when they're still in the lineup room, that is an important sign?
Yes, one of the problems with confidence is by the time the witness has gotten to the courtroom, they have not only made the identification that was confirmed, like Jennifer Thompson, good, you got the scumbag. Sometimes Gary Wells, an eyewitness researcher, talks about a case where the police in the room burst into applause when the suspect was identified. That kind of confirmation changes a witness's confidence and also changes a witness's memory of the conditions under which he or she saw the whole thing.
Let me, I know we have to move, but let me add one small thing, because Peter, I don't think we disagree, though I'm trying to give the most optimistic picture, because I don't want the picture to be we all think police officers are bad people. Though there are police officers, well, everybody works with cognitive biases, and they're even worse. But one of the things you notice...
We don't all make life and death decisions.
No, that's absolutely right. And look, police officers, one of the things, speaking of things we can do to make these processes better, you can take a police officer who is an impeccable police officer as best they can be and show them a videotape of them interviewing a witness and then point out to them quite unconsciously how they have provided the witness with all the information that they took to be confirming, right? How without meaning to, they slip in all sorts of facts that the witness then repeats to them, and they think, oh good, I can be confident this witness knows things that they wouldn't have known if they weren't part of the crime. And you know, so people do studies like this, and then you show the officer, and the officer's aghast, because they're not a terrible person.
Well, it's like showing someone their parenting style on videotape.
Yeah, and you know, and then the worst of it is, of course, there is the officer who, even again if they're not the worst person, you know, the officer who is not terribly worried because they think, look, this is a bad person, and if he didn't do this, he did something.
Yeah.
Right? And so you layer these cognitive biases onto each other, and it becomes very easy for an officer, even a not cinematically terrible officer, right? Because the cinematically terrible officers are out there, but the problem is if that's all we're looking for, then we're missing the boat.
Let's talk now, and the bias question will come in here as well, cognitive bias, false confessions. Because we've now talked about the words of the witnesses, let's talk about the words of the suspects. Because we've all watched the shows talking about cinema, CSI, Law and Order, now there's True Detective with these interrogations being filmed, and we've got interrogations not being filmed, and confessions coming out, many of them false. Peter, tell us the story of your first DNA exoneration that was tied to a false confession, if you don't mind.
So it was our first case where the police had actually made an audio tape of the confession. And what was extraordinary is that 2 white women were raped on the Philadelphia main line, a few weeks apart, a mile apart, late at night in their respective homes. And they had great details about the way in which the crime occurred. And for instance, one of them was menstruating, and the perpetrator removed a sanitary napkin and hid it under the night table, removed the screen and put it in a particular place, all those kinds of details. And he asked us to take his case, and the district attorney gave me the audio tape of his confession. And the confession had all those details. And the officer's saying, so what did you do next? And he talks about, well, then I removed the sanitary napkin and I hid it here. And how did you get in? Well, I took the screen off the hinges and then I put it over on the table. And I'm going, oh my God, this guy's guilty, we shouldn't take the case. And one of the reasons that I felt that way is, years ago I was a criminal defense lawyer, and if I was told that my client confessed, that was the end of the case. You wanted to get the best possible plea bargain. That was it. Because we couldn't appreciate that a truly innocent person would ever confess to a crime he didn't commit. It's totally counterintuitive. None of us would think we would do that. And so, therefore, he had to be guilty. The end of the story is, of course, that we do the DNA testing, and the women were right. One guy did rape both of them. It just wasn't this fellow. It turned out to be someone else, and this guy was completely innocent. Because what happened is something that Ekow was referencing earlier. What happened is that the police became so sure that this was the guy, because they had both identified him as well, identified his picture, that when he's being questioned, before they turn on the tape recorder, and he starts saying, you know, I did it finally, I did it. Well, I said, well, how did you do it? And the reason the how did you do it is extremely important is the police are trained to hold back certain details about the commission of a crime. So when someone does come in and say, okay, I did it, the way the officer can distinguish between a true confession and a false confession is if that person then voluntarily describes all these extraordinary details, such as the removal of the sanitary napkin and sticking it under the night table. Okay, the problem is that the officer was so sure he had the right guy that when this fellow didn't provide those answers voluntarily, he said, oh, come on. And then you took a sanitary napkin out and you hid it under the table. But of course, that's not on the audio tape. The only thing that's on the audio tape is the denouement, is that last moment where he's now giving it back and saying, I did it, and this is how I did it, and that's it. So unless you have the 3 hours of tuning up that preceded that moment of climax, then you, the listener, are really in a bad place to evaluate that confession.
So they're feeding him those very specific facts necessary to obtain the confession that will be played in court.
Well, it's not just to obtain the confession, it's to make sure that everybody who's going to hear that confession will know it's a reliable confession as opposed to an unreliable
It's
one.
almost as if you hear those very specific, bizarre facts, and you should be somewhat suspicious. That's almost too good to be true.
No, you wouldn't be suspicious because actually the person who committed the crime would know those things. We had a murder case where the perpetrator, the real perpetrator, literally carved his initials into the deceased. Mm-hmm. And that was kept away from the press. No one in the community knew about it. And then this gentleman was interrogated, and during the interrogation they said, so how did you do it? And he said, well, after I killed her, I took out my knife and I carved my initials in. And that's something that the real perpetrator would remember.
And this guy was guilty.
And this guy said it. It turned out that, in fact, he was completely innocent. The DNA testing proved that somebody else who was a serial murderer committed the crime. But the officer was just so convinced that he did it after he said yes, finally, during coercive questioning, that he thought he was just holding back on admitting that he knew those details. So the officer felt, well, I'll just help him along a little bit.
Did they have the same initials?
Jim, let's talk about the techniques police officers use to get a confession. What are they allowed to do? What are they not allowed to do? Is there anything they're not allowed to do?
Sure, they're not allowed to use physical force. They are allowed to put forth scenarios to a suspect and say, listen, I'm sure that this person provoked you in some way. They taunted you. Maybe they said that you weren't really a man, and you had to explain to them that you were a man, and therefore you slapped the victim around, or you beat them up so badly, or you knifed them. And they'll put forward scenarios in which the culpability seems at least spiritually less than simply being a psychotic who stabbed someone to death.
Can they lie?
They can lie like rugs. They can tell anything they want, and they often will say, look, we've done the lab work. The lab's got your semen, or the lab has whatever from you, and we're going to find out that you did it, so you might as well tell us. Or they may even say, we have lab results, and they point at you, even if they don't. Now, there are some limits to this, but the limits are pretty elastic. And for instance, in mentioned the Central Park jogger case, one of the things a detective used in that case was he told one of the boys that his fingerprints had been found on the jogger's pants, on her silk running shorts. And when he, and he testified to this in court. And it was one of the few, he said, I lied, of course. I had no fingerprint. You can't get fingerprints off silk, John. And he said, I was just trying to get him to tell me the truth. And so I lied. And actually, it was very effective as a piece of testimony because it was the first time one of the cops actually came in and was forthright about their techniques.
Right.
And it was very persuasive because of that.
Because he was honest about those techniques.
Because he was honest about it. And then, so then they'll say, or they'll play two people against each other.
I was just going to ask about
your partner, he's crazy. I know he's crazy. You probably couldn't have stopped him, but what happened? Did you have to hold the victim down when he was raping her, or did you have to, did you hold the gun and did it accidentally go off and he make you hold the gun?
He's already said you did it.
They call it minimalization,
right?
Maximization, right? You minimalize your culpability. And what you maximize somebody else's.
Now let's focus a
Just
little bit.
for clarification, folks should know that although lying and deception is permitted under the law in the United States, many other countries prohibit it. In England, it's prohibited. In most of Europe, it's prohibited because they realize the danger of innocent people falsely confessing.
Why is that not? Why is our permissibility, our constitutional permissibility, different here?
Why is a hard question. The U.S. Supreme Court visited that issue last
Why
in
are you
19...
tossing that to Saul?
Oh, because you're asking a legal question?
Go ahead. No, either one. I'll take it from anyone. We can all address that.
The U.S. Supreme Court has not resolved this issue. The last time they addressed it was in 1969. And they came out of it saying they do not believe that lying to a suspect about evidence puts that suspect at risk. They are wrong. It is a sparingly used tactic. But in almost every single false confession case I have ever seen, that tactic preceded the false confession. It is what breaks a suspect down into a state of despair. Sometimes it even has the effect of disorienting and confusing the suspect. You would be amazed at how many of these people actually come to believe they may have committed this crime. And the reason they believe it is they're sitting alone in a police station being delivered one lie after another about the evidence. They presume that the police are telling the truth, and therefore the burden falls on them to reconcile the fact that they don't remember doing this, but he seems to have this unimpeachable evidence. How is that possible? And all of a sudden the conversation turns to consciousness and memory. And the idea comes to the suspect that perhaps I did commit this crime, I just didn't realize it, or I don't remember it. So false evidence, and we have demonstrated this in the laboratory, you can see it in actual cases. The presentation of false evidence breaks suspects down into making false confessions, into doing the thing that people think they would never do, which is to confess to a crime they did not commit.
Now, it is true, Ekow, that some people are more likely to confess than others. Certain categories of people. Who are they?
Well, so I was going to say, one of the things we have to remember is the average is such a weird way to put it, but when you're picturing a confession, you shouldn't be thinking about yourself now in a cool, nice room in your suit with your faculties. We're often talking about young men, right? People who've gotten into trouble before, maybe, or people who, now I'm in the odd position of my students thinking I was born a law professor. So people treat me as though I was just born a law professor. Not everybody's treated like this. Not everybody's treated with deference. Not everybody. So if you're a different person, maybe you're younger, maybe you're black, maybe you're poor, maybe you've been in small trouble before, even big trouble before. Let me give you an innocuous one, right? Your teacher never believed that you didn't do X, so you got detention, right? You were speaking about cognitive biases. Once we decide that Bob is a bad kid, we just interpret everything he does differently. The thing is, this has an effect on Bob too, right? Because Bob gets used to the idea that nobody believes him, nobody's on his side, I got in trouble. It sounds silly, but after hours and hours of questioning, Bob's life story where, gosh, nobody's ever believed me anyway, runs just as quickly from detention in middle school to now you're 20. You're not that old, right? 20. Gosh, I remember feeling old at 20. You're so young. You've been being questioned for a long time. The officers are, as my colleagues have said, are very good at describing the story in a way that makes you seem like you didn't do anything that bad, right? And then after they get the confession, they slowly remove all the excusing details, right? To make sure that the final confession is whatever the maximum confession they can get. And lastly, and I think this is not at all trivial, you're exhausted. So, you know, they interview people after false confession. They say, why would you confess? And they say, I just wanted to go home. Right? I just
And they
wanted
promise
a break.
you can go home.
You can go home, your mom, look, get this off your chest, you'll feel better, you can talk to your mom. And people just, it sounds silly, but gosh, if I can just go talk to my mom, right? I'll just tell them what they want to hear. And they've described it in a way where you haven't done anything all that terrible, right? And you're exhausted, et cetera, et cetera. Now, the last time the Supreme Court did revisit this issue, the last time the court actually pushed back on policing was roughly after World War II, where I think we were very conscious as a nation from what had happened in Germany about police tactics. And that was a high watermark for the court policing what exactly and how far you could push, what counted as coercive interrogation. But since that short period, maybe culminating in Miranda, we've seen nothing but the waters recede. And now we sort of return to this idea that it's like some sort of fox hunt and all is fair game.
How, Jim, does everything Ekow just said fold into the case you mentioned, the Central Park jogger case?
Those 5 boys, teenage boys, were picked up in April 1989 on an evening after there had been a lot of trouble caused by teenagers running through the park. They were being processed for disorderly conduct when in the middle of the night somebody discovered an unconscious woman in the park nearly dead. And she had been raped and she'd been brutally beaten on the head, and holy smokes, these kids were in the park. Hold on to them. And they started questioning. I think there may have been about 20 or 30 kids ultimately questioned. And 5 of them were held for close to 24 hours, and they eventually, in a period that was not recorded, that was not interrogated, there was no documentation of what went on up until the time the cameras were turned on. And then each of the kids gave a statement. Corey implicated Yusef. Yusef implicated Raymond. Raymond blamed Kevin, and so on and so forth. Each one of them described a different kind of sexual assault and beating of the jogger. And each of them said, I was just standing there, or I held her arm for a second. And every one of them had a different story about it. But they all put themselves in the soup. They all admitted to being, in some way, part of this assault.
All of them, getting back to what Ekow said, young.
Right.
One of them mentally disabled.
One of them not only mentally disabled, and I think
The oldest one was mentally disabled.
the oldest one was, he was developmentally disabled. He also was deaf or very hearing impaired, and did not have a hearing aid.
With him at the time.
Wasn't wearing one at all for most of his youth. And so when you see, we're going to see his film in a minute or two.
Right now.
Watch how he is watch what his eyes are doing as he's speaking.
And they're all separated from one another and not permitted to speak with their parents.
That's not entirely true.
Some
of them, yeah. Corey was not with his parents.
Right.
Yusef was not with his parents.
Raymond's parents came.
Raymond's father came, but then he went to work.
Yeah.
And then his grandmother, who didn't speak English, was sent to sit with him. So it was kind of a meaningless exercise.
All right, we're going to listen now to, again, a warning that it's somewhat graphic. So if anyone wants to take a break, it's 49, 50 seconds of somewhat graphic testimony.
Steve called me a punk because I didn't do it. They hold it down. And what you call Steve ripped her pants with his knife. That's what made her mad. And that's when she started scratching him. What's her name? Kevin. She was yelling pretty loud. She used to close their mouth. They had bigger heads than us. Close their mouth. So we were looking at her, and I felt kind of bad. This is my first experiment I did to any type of female in the street. This is my first rape. I never did this before. This will be my last time doing it. This is my first experiment. This will be my last.
heartbreaking. You can hear the impairment in his conversation. How many years did they spend?
Well, Corey actually spent 13 and a half years. But the interesting thing is that we didn't know, I didn't know, and I don't think anybody who sat on the jury knew that Corey was hearing impaired at the time of his interrogation. So I sort of tipped all of you off to watch for that. But Saul, what do you think a jury thought about that when
I defy any judge or jury to disbelieve this statement. And this is 50 seconds that comes on the heels of a very graphic description of who did what to whom, when, and how. And not only that,
and 1 of 5.
He reflects on his own mental state. He apologizes and expresses remorse. He doesn't just give details about the crime. He gives statements about why he did it. He didn't want them to think he was a punk. That's why he participated. And he regrets it now. All of that is contained in a false confession. 95% of false confessions contain graphic details like his about the crime that supposedly only the perpetrator could have known.
in their case,
this is a statement that is scripted and rehearsed, and it isn't until it's scripted and rehearsed that the camera is turned on for all of us to see.
in their case, what's unusual in their situation is that the detectives and the prosecutors did not know what actually had happened. The victim was in a coma. She was thought to be going to die. And so they didn't have her identification. They didn't know anything about her movements. So when the boys confessed, no one could say to them, well, this probably happened around 9:15, didn't it? Because of she left. They didn't know. Later on, they were able to find out what time she left her house, what her route was, and all that other stuff. But at the time, they didn't know that. So the boys' confession is wrong about when the crime took place. All of them are wrong about where it happened. Some of them put it a half mile from the site, a quarter mile. And they're all wrong about how it happened, except to the extent that it did happen. They describe injuries that were not consistent with her injuries. There's a big bloody mess. And so anything that they said served.
Peter, what is the recommendation that the Innocence Project makes with regard to false confessions, interrogations, and how to correct this problem?
Well, again, because if you go back to what we did with ID, if you're trying to figure out a way to avoid cognitive bias, because let's assume for the moment that when police officers feed those details, that they are not doing it malevolently. Let's assume that they really think they have the right guy, and once they've worn him down and he says, I did it, and then they ask for that narrative, they think he's simply holding back. But if you had a videotape, not a videotape that starts at the climax as it did in the Central Park jogger case, but at the very beginning when the person is brought into the interview room, okay, and they read him his rights, the very beginning. And then you have an objective, neutral record of everything that's said. Then the jury, then the judge will know, well, with these non-public details that we're talking about, those held back facts, did they originate with the accused, or were they fed to him during the course of the interrogation by the police officer? Did the police officer show him photographs to familiarize himself with what the crime scene looked like? Or did he on his own, without any kind of help at all, describe what the crime scene looked like? Then you'll know. If it can pass that kind of test, then you have more confidence in the reliability of the I did it. If it doesn't pass that test, you shouldn't have confidence in it at all.
The psychologists have a great expression that they use to describe a confession in which details have been inadvertently fed. They say the confession has been contaminated. Mm-hmm. And that's the perfect phrase, I think, for it. And in the bulk of this is an amazing fact, I think of the DNA exonerations where somebody falsely confessed, 90% of them, those 95. People, 95% of those folks actually knew details about the crime that no one.
Well, they didn't actually know them.
But what they cited.
They were included in their confession.
Yeah, when they confessed, they included those details.
All right.
How did they get them?
And we can leave that question hanging. I think we can answer it
Yep.
in our minds. All right, so we're going to move on now to the next part of our program. I'm going to say a temporary thank you to Saul and Ekow. Thank you very much for being with us. We're going to see you again in just a few minutes. Professor Saul Kassin and Ekow Yankah. And here comes Mechthild Prinz, and she's going to join us now to talk about her work in the hard sciences. And she's a forensic scientist who has spent most of her career as a DNA specialist and a crime laboratory manager, providing DNA results for criminal casework, missing persons, and disaster victim identification. She is a professor at John Jay College, and we thank you very much for being with us.
Thank you very much.
So we know that absolute truth is probably never possible in a court of law. I think everybody can accept that. But maybe you can help us to understand the difference between something that is a hard science, like DNA, and other things that we hear about, like blood spatter and fingerprints and hair analysis and fiber analysis. Are those things science, like DNA is?
There is definitely a scientific method behind it. The difference is that if you have a DNA test, you have a background of population genetics data that will inform you about the rarity of finding a positive association. And you're absolutely right. You never should say 100%. There is always uncertainty because there is a lab error component to it. But for DNA, which is a science born out of biological research and genetic research, we do have databases that will tell us how often to expect to see a certain DNA profile. Those databases don't exist for fingerprints, for example. Fingerprints were not born in a crime lab. The original application was actually in India, where somebody used to have people put their fingerprint on a contract. He just kept their identities straight. And in Argentina, they were using it to track the identity of prisoners. And that obviously works, because if you have very pristine fingerprints, you can tell people apart. So some of the problems that have occurred with fingerprint evidence in crimes is the fact that you do not have those types of pristine prints.
I think Mechthild, who I do respect a great deal, and has done a lot of fabulous work in the area of forensic DNA testing, is being too generous to some of these other forensic disciplines. And if you think about it, it's actually very, very obvious to any layperson. In all these other disciplines, including DNA, what you're trying to do is you look at some crime scene evidence, and you're trying to determine the source of that evidence. You're basically asking two questions. The first hypothesis is, can I associate this evidence found at the murder scene with the suspect? The suspect is Jim Dwyer, okay? So the first question is there a positive association? Are they similar? Are they a match? The second question is, let's assume there's a positive association, there's a match. Well, what is the significance of that match? So for instance, if all I know is that the perpetrator was a male, and Dwyer's a male, it's a match, but frankly, it's not very probative. If on the other hand, the perpetrator was 7'4", right, and Dwyer's 7'4", it's much more probative. But to answer those two questions requires the application of the scientific method. To answer the first question, is there a positive association? You need empirically tested methods to determine when two things are the same or when they're different. Some kind of objective methodology. For most of these other disciplines, there's not an objective methodology. It's subjective. A trained examiner says, based on my experience, I say it's a match. But someone else might say it's an exclusion. So it's missing that first.
It's more art than science?
Well, my son's an artist, and I have a lot of respect for him. So that's the first problem. The second problem is that even if you have the positive association, again, is this a situation where it's just they're both male, or is it the 7'4"? So you need databases. In DNA, they have databases So when you have that positive association, you can make a scientific estimate on how powerful that evidence is. But in these other disciplines...
That's what I said. I said there is no database for many of the other disciplines. Many of the disciplines, I know, I would distinguish between a material science, chemical type of disciplines where you identify a fiber based on the chemical composition. That is clearly a scientific method. Toxicology, drugs coming out of chemistry is a scientific method. There are disciplines where what you're doing is a visual comparison.
But Mekhi, even with the fiber, you can say, yes, it's a DuPont 401 nylon, but unless they find a fact has some idea how common or rare is DuPont 401 nylon, the evidence can be very misleading.
I totally do not disagree with that at all. Clearly, you find a white cotton T-shirt fiber at the scene, it's absolutely meaningless. The only information you have is male 6.4. It's not enough. It's not. You have right now no tool to.
No baseline.
No scientific method to express the significance of what you find.
All right, let me ask you about the National Academy of Science report 5 years ago, right? 2009?
Right.
Talking about strengthening forensic science in the United States. What does that tell us about this debate you're having?
So the report, as unfortunately a lot of things in our society, something has to go wrong before people start thinking about it. You get a traffic light. Once there was an accident at that crosswalk. And so I think it was based on the Madrid bombing case that the commission was convened. And they found a lot of problems. They found unaccredited laboratories, improper documentation, shoddy work, and they made a big call for more research, more quality assurance, better education. They made a call for a national, agency to give guidance and start rehabilitating forensic science and putting it on good footing. And one of the big things also was the lack of statistics.
One thing that's a great example of the weakness of this whole thing, there was a guy down in a forensic odontologist, right? This is a dentist who says he can identify bite marks on someone's skin and match them to a suspect. And there's a guy down in the South who was frequently testifying in capital murder cases that he could prove beyond all doubt and without any hesitation that so-and-so, this defendant, left the bite marks on this victim's body. Well, in each and every one of those cases, the defense would bring in their own forensic odontologist who would say, no, these bite marks don't match. That's not science. Right. I mean, that is a coin toss, and nobody can make any sense out of that at all. And but it has this veneer of science because people come in called Dr. West. This was this guy, right? And was he the one with the blue light too, Peter?
Yes.
Yeah, he would have a magic blue light and he'd find bite marks that nobody else could see.
But but one actual comment about, which comes back to the question of cognitive bias.
Yeah.
So jurors, even though they'd have opposing experts, invariably voted to convict. Oh. They voted to convict because the odontologist of the prosecution was simply, working for a state agency, whereas the expert who's retained by the defense is being paid, so he's not as credible. Plus, we in the jury need closure. A horrible crime occurred, right. A 3-year-old girl has been sexually assaulted and killed. We need closure. If not this guy, then who? Right. So let's just convict him. And that happens again and again and again because of that same kind of bias.
Let me come to you, Mekhi, on this issue of the cognitive bias. Because we talked about it before we began the program. How do we deal with issues of bias as scientists? Forensic scientists, people working in labs, people collecting evidence at crime scenes, scientists in general. I mean, we're all going to bring, and I'm not talking, as Peter said earlier, I'm not talking about the kind of bias we generally talk about as lay people. I'm talking about procedural bias in our work. If you're going to go to a crime scene and collect evidence, or if you're going to be working in the lab, how are you going to shield yourself from the kind of cognitive bias that we've been talking about tonight?
It is definitely a fact that people working in a laboratory, they are humans, and if this type of information can slant your opinion, and that has been shown in scientific studies. So the best thing you can do is, of course, education. And not everybody needs to know everything, obviously. You need a certain amount of background information to scientifically decide on your sampling, or to know when to stop to sample. You need to know how many people were bleeding. In New York City, the New York Post always knows who did it, so I can't stop the analysts from reading the newspaper, but it's not a good idea to have these conversations with the detective all the time. It is better to put a case management unit in between, because it is true, things are said like, oh, this is a bad guy, you gotta help me to get him off the street. We have heard these things, but you do need in order to have an integrated approach where multiple disciplines work together, you need to know what the investigation is about. Many cases are actually analyzed prior to there even being a suspect. So at the crime scene, normally, very often there is no suspect yet. And
many cases go unsolved entirely. I mean, we haven't talked about that reality.
Yes.
Saul, I need to bring you back sooner than you probably thought, but I'm looking at my clock. Saul Kassin is back. He's going to help us see how you have done with your eyewitness identification. I know, some of you forgot, didn't you? All right, so Saul, you have a photo array, don't you?
I do.
There it is.
This is the six-pack we talked about. I should instruct you the way police are instructed to instruct witnesses, which is the perpetrator may or may not be in this group of photographs. It is important to say that and to preface the lineup with that, so that you don't feel compelled to make a decision. He may or may not be in here, the person who did this. Take a close look at the 6 photos. So here you have 6. I guess the vote we're asking you to take is, first of all, do you think the person who stole my iPad is in this group? And if so, which number is he?
All right, are you ready?
Bring it.
Bring it. Bring it back.
Oh my. Okay, the first thing you notice is a pretty healthy distribution across all pictures. That makes this a tough lineup. I noticed that the most common pick is number 1. How many of you picked number 1? 1. Excellent. How many of you who picked number 1 are confident? Very confident? Would you go to court with it? Would you testify?
Pay?
In a lab coat.
Lay witnesses cannot be paid.
Because number 1 is an innocent foil. Number 1 didn't do it. Number 2 didn't do it. Number 3, a lot of choices down on number 4. How many of you picked number 4? With confidence? Enough to go to court with? Wrong.
Saul, do you want to tell him who number 4 is?
Who is number 4?
Number 4 is in the room.
Oh,
He's
right.
your cameraman today.
Now that makes...
Don't feel bad.
And he's done it twice before.
He's done it twice. That might sound like an irrelevant detail, but there is a phenomenon known as unconscious transference, whereby a witness would identify someone who is familiar because they were at the crime scene,
Well, that's not irrelevant.
although they were not the criminal. So maybe that's what drew you some 22%. And then we have a tie between 5 and 6. One of these 2 individuals actually stole my iPad, and it is number 5. In a room of, I don't know how many people are here, wow.
83% got it wrong.
Right,
Is Chris still here?
83% got
did
it
he leave?
wrong.
He left because he was guilty.
83% got it wrong, and as we mentioned earlier, I would surmise that those of you who got it wrong are probably no less confident than those who picked number 5. And the worst part is, the confidence you have now will only grow between now and the time you get into a courtroom, because you will receive confirmation after confirmation. So by the time you appear in court, you are so dead sure of it that any jury that hears your testimony will believe you and vote for conviction.
So can I make a pitch for science? So you better hope there's physical evidence and you can get good results.
That's a great way to end. Thank you all for coming. And thank you. Thanks to the panel. Thank you all very, very